All right, let's take this step by step, word by word, in the simplest way possible. I will explain it like I'm teaching a young child who knows nothing about the topic. Here's what you need to understand. 1. What is criminal procedure? Criminal procedure is like the rules of a game. It tells us how to catch bad people, lawbreakers, how to put them on trial, and how to punish them if they are found guilty. 2. Why do we need criminal procedure? Imagine this. There is a rule that says no stealing. There is a punishment for stealing, like going to jail. But if there is no one to check who is stealing, catch the thief, or take them to court, then what is the point of that rule? It's just words on paper. No one will take it seriously. 3. What does criminal procedure do? Detects crime, like finding out who stole your toy or broke your window. Prosecutes criminals, like taking the thief to the judge and saying, this person did something wrong. Punishes criminals. If the judge finds them guilty, they get punished, like going to jail or paying a fine. Without these steps, people would break rules without any fear. 4. Example to make it simple. Let's say there's a rule. Don't hit your classmates. You hit your friend. If the teacher doesn't see it, doesn't ask who did it, and doesn't punish you, you might think it's okay to hit others again. Criminal procedure is like the teacher. 1. The teacher finds out you hit someone, detects the crime. 2. The teacher asks you to explain, prosecutes you. 3. If you're guilty, the teacher might punish you by making you apologize or stay after school, punishes you. 5. Why is it important? If there's no punishment for breaking rules, people won't follow them. Imagine if thieves and murderers were never caught or punished. The world would be full of chaos. Criminal procedure makes sure that everyone is scared to do bad things because they know they'll get caught and punished. Extra information. Substantive criminal law. These are the rules that say what is wrong, like stealing is bad or killing is bad. Criminal procedure. This is the process of making sure those rules are followed and bad people are caught and punished. In short, 1. Rules. Say what's right and wrong. 2. Procedure. Make sure those rules are followed. 3. Example. Without rules and punishments, bad people like thieves won't stop stealing. Now, if you still have questions, I'm here to explain further. All right, let's go even deeper and keep it very simple. I'll explain every part of what you've shared in the clearest way possible with examples so you fully understand. 1. What is criminal procedure? Criminal procedure is like a set of rules that tell us how to deal with a crime, how to treat people fairly, whether they are guilty or innocent. For example, if someone steals money, criminal procedure gives clear steps to 1. Find out who stole the money. 2. Catch the thief. 3. Prove whether they stole the money or not. 4. Punish them if they are guilty. 2. Why do we need criminal procedure? Let's break this into simple ideas. 1. Rules alone are not enough. Imagine a law says no stealing. If there's no proper way to catch thieves or punish them, the rule is useless. People will steal because they know they won't get caught. Example. If there's no teacher in a classroom, kids might break the rules, like talking loudly or hitting each other. No one is there to enforce the rules. 2. Criminal procedure makes rules work. It ensures there's a proper process to find and punish wrongdoers. It also ensures that innocent people are not punished by mistake. 3. What does criminal procedure do? It has 5 main jobs, explained step by step. Step 1. Detect the crime. This means finding out if a crime happened. Example. If someone's bike is stolen, the police will investigate to see if a theft actually took place. Step 2. Arrest the suspect. This means catching the person who is suspected of committing the crime. Example. If someone is seen stealing a bike, the police might arrest them. Step 3. Collect evidence. This means gathering proof to show if the suspect is guilty or not. Example. The police might check CCTV cameras to see if the person was stealing. Talk to witnesses who saw the crime. Look for fingerprints or other clues. Step 4. Decide guilt or innocence. This is done in court by a judge. The judge looks at all the evidence and listens to both sides. The police or lawyer says, this person did the crime. The suspect says, I didn't do it. The judge decides if the person is guilty, they did the crime, or innocent, they didn't do it. Step 5. Punish the guilty. If the judge says the person is guilty, they get punished. Example, a thief might go to jail. Someone who damages property might have to pay money as compensation. 4. How does criminal procedure protect innocent people? Criminal procedure ensures that 1. Innocent people are not punished for crimes they didn't commit. 2. Everyone gets a chance to explain their side. 3. Police or judges cannot harm or unfairly treat someone without proper proof. Example, if someone is falsely accused of stealing, the law ensures they get a fair trial where they can show evidence that they are innocent. 5. Balancing power. The law gives police and judges power to investigate and punish. But this power must be used carefully. Criminal procedure ensures police and judges follow rules and don't misuse their powers. If they misuse their power, they can be punished. Example, a police officer cannot arrest someone just because they don't like them. They need proper reasons and proof. 6. Why is this important? Without criminal procedure, 1. The police could arrest anyone without proof, which would be unfair. 2. Powerful people might abuse their power to harm innocent people. 3. There would be chaos because no one would trust the justice system. Criminal procedure makes sure that 1. Rules are followed. 2. Everyone is treated fairly. 3. Innocent people are protected. 7. Example in daily life. Imagine you are in school. Rule: no one should cheat in exams. If someone cheats, the teacher doesn't immediately punish them. Instead, 1. The teacher investigates, finds out who cheated. 2. They collect evidence, check the answers, talk to classmates. 3. They listen to the accused student's side. 4. They decide if the student really cheated. 5. If the student cheated, they get punished. If the teacher didn't follow these steps, innocent students might be punished unfairly. Criminal procedure works the same way in real life. 8. Summary. Criminal procedure is a system that ensures crimes are handled fairly. It has 5 steps. 1. Detecting crimes. 2. Arresting suspects. 3. Collecting evidence. 4. Deciding guilt or innocence. 5. Punishing the guilty. It also protects the innocent and prevents the misuse of power. This makes sure that justice is fair for everyone. If you want even more details or examples, I can explain further. Let me know what part is still unclear. Alright, let's break this down in the simplest possible way and ensure you understand every part clearly. 1. Importance of criminal procedure. 3 key reasons. Reason 1. Criminal procedure affects more people constantly than any other law. Criminal procedure deals with everyday matters like crimes and punishments. Example, imagine speeding on the road. The traffic rules apply to everyone who drives. Without criminal procedure, police wouldn't know how to handle these situations. This makes it one of the most frequently used laws affecting people all the time. Every person, whether you're a criminal or not, gets touched by criminal procedure in some way. Police, they investigate. Judges, they decide. People, they are suspects or witnesses. Reason 2. Human values are involved in criminal procedure. Criminal procedure isn't just about rules, it's about people's lives and rights. Example, imagine if someone is falsely accused of a crime. Without fair procedures, they might get punished even if they didn't do anything. It's about making sure innocent people are protected and not punished by mistake. If we don't have strong criminal procedure, human rights could be ignored. Human values like fairness, justice, and dignity are at the heart of criminal procedure. Reason 3. It supports substantive criminal law and protects society. Criminal procedure doesn't work on its own. It supports substantive criminal law, which defines crimes and punishments. Substantive law says things like, murder is punishable by law. Theft is illegal. Without proper procedure, these laws can't be enforced effectively. Example, a speeding law might say, you can't drive faster than the limit. But if there are no rules for catching speeders or issuing fines, the law becomes useless. If criminal procedure fails, Even good laws like no stealing or no killing will be useless. Society will suffer because bad people will continue to do bad things without fear of punishment. Example to make it clear. Let's say there's a law that says no stealing. If a thief steals something, the police have to catch them. The judges have to decide if they are guilty. Without proper criminal procedure, the thief might get away. People who are guilty of serious crimes may not get punished. The fear of being caught or punished disappears. In this situation, good laws are powerless because criminal procedure wasn't applied properly. Conclusion. The importance of criminal procedure is clear because it affects so many people, protects human values, and supports the overall functioning of criminal laws. If there's too much delay, expense, or confusion in applying these procedures, even great laws will lose their meaning and fail to protect society. Let me know if this explanation helps or if you need further clarification. All right, let's take it even slower and explain everything in more detail while keeping it simple. Imagine you're learning this for the very first time, and I'll guide you step by step. 1. Heading, short title, extent, and commencement. This heading means the law is giving us 3 important details. 1. Short title. What is the name of the law? 2. Extent. Where does this law apply? Which places? 3. Commencement. When will this law start working? Top 2. 1. This act may be called the Bharatiya Nagarik Suraksha Sanhita 2023. Let's break this into parts. This act, an act is like a set of rules made by the government. These rules must be followed by people. B. May be called. This means the name of these rules is given here. C. Bharatiya Nagarik Suraksha Sanhita 2023. Bharatiya means Indian, for the people of India. Nagarik means citizen, any person living in India and who is an Indian. Suraksha means safety or protection. Sanhita means code, a book of rules. 2023 is the year this law was made. Putting it together, the name of this law is the Bharatiya Nagarik Suraksha Sanhita 2023. It is a law about keeping Indian citizens safe. 3. The provisions of this Sanhita, other than those relating to chapters wine and sound thereof, shall not apply. This sentence might feel complicated, but let's make it very simple. A. The provisions of this Sanhita, provisions are the rules or parts of the law. Sanhita means the code or this law. So it's talking about the rules in this law. B. Other than those relating to chapters 1 and 2. This means chapters 1, Sem, and 2 are special parts of the law. These chapters will still apply everywhere. We will explain this below. But the rest of the law will not work in certain places. Shall not apply. This means most of the rules in this law will not work in some places. 4. A. To the state of Nagaland. A. State of Nagaland. Nagaland is one of India's states. It is in the northeastern part of India. It has a unique culture with many tribes and languages. B. Shall not apply. This means most of the rules in this law will not work in Nagaland. B. To the tribal areas. A. Tribal areas. Tribal areas are places where tribal people live. Tribal people are groups who follow their own traditions, languages, and ways of life. In India, these areas have special protections because tribal cultures are different from the rest of the country. B. Shall not apply. Most of the rules in this law will also not work in tribal areas. 6. Chapters 9, 1, and 12. These chapters are exceptions. Even in Nagaland and tribal areas, these 3 chapters will still apply. Why? Because these chapters might contain rules that are very important for everyone, no matter where they live. 7. Why some areas are excluded. India has many different kinds of people, cultures, and traditions. Some states like Nagaland and tribal areas are special. They have their own rules and systems to protect their way of life. That's why the government decided that most parts of this law will not apply there. Example to understand. Imagine you make a rule in school. Everyone must wear a uniform. But some students, like those from sports teams, are allowed to wear their special uniforms. Here, uniform rule, the law. Sports students, Nagaland and tribal areas. Special chapters equals important rules that everyone still follows, like safety rules. Half final explanation, simplest words. 1. This law is called Bharatiya Nagarik Surakshha Sanhita 2023. It is made to protect the safety of Indian citizens. 2. Most of this law will not work in the state of Nagaland, tribal areas in India. 3. But some important parts of the law, chapters 9, WEMS, and 12, will still apply everywhere. 4. The government excluded these places because their people have unique cultures and rules which need to be respected. Extra tip. If you want to know what chapters 9, Thyme, and Thessalon include, I can explain that too. Let me know. Alright, let's take this slowly and break it into the most simple words possible, step by step. Imagine we're sitting together, and I'm explaining this to you like it's the first time you're hearing about it. Sentence. But the concerned government may, by notification, apply such provisions or any of them to the whole or part of the state of Nagaland or such tribal areas, as the case may be, with supplemental, incidental, or consequential modifications as may be specified in the notification. Breaking it down, but the concerned state government. Who is the state government? Every state in India has its own government. For example, Nagaland has the Nagaland state government. Assam has the Assam state government. Concerned means the one involved. Here, the sentence is talking about the government of Nagaland or the government of a tribal area. 2. May by notification. This may means permission. It says the state government is allowed to do something. It's not compulsory. It's their choice. By notification means making it official. The government needs to write it down and tell everyone officially. Example, like an announcement in a newspaper or on their website. 3. Apply such provisions or any of them. Apply means to use the rules. The state government can decide to make some parts of the law work in Nagaland or tribal areas. Provisions means the rules in the law. Not all rules may work there, but the government can pick and choose. 4. To the whole or part of the state of Nagaland or such tribal areas. The state government has two choices. 1. It can make the rules work in the entire state or area. 2. It can make the rules work in only a small part. Example, if Nagaland's government thinks this law is important only in the city of Kohima, they can apply it just to Kohima. They don't have to make the law work in the entire state. 5. With such supplemental, incidental, or consequential modifications. This part sounds tricky, but let's simplify. Supplemental means extra changes. The government can add extra rules to make the law work better in their area. Incidental means small related changes. They can make tiny adjustments to the rules to fit local needs. Consequential means effects or results. If applying the law leads to new problems, they can fix those too. Example, imagine the law says police can act within 24 hours. Nagaland's government can change it to police can act within 48 hours if that suits them better. 6. As may be specified in the notification, this means the state government will write down all the details in the official notification, which parts of the law they are applying, where they are applying it, what changes, modifications they are making. Complete simplified explanation. 1. What does this mean? The Nagaland state government or the government of a tribal area can decide if they want to use parts of the law. They can use it for the whole area or only for specific parts. They can also make small changes to the law so it works better for their people. 2. How will they do it? They will make an official announcement called a notification. In that announcement, they will explain which rules they are using, what changes they are. Example for better understanding. Imagine there's a school with 100 students. The principal makes a new rule. Students must wear uniforms on all days. Now, the sports team students don't want to wear uniforms because they have their own special clothes for practice. So the principal says, 1. Sports team students, like tribal areas, can follow only some parts of the rule. 2. If they follow the rule, they can wear their sports uniform instead. This way, the rule is modified to work better for the sports team. Why does this happen in Nagaland and tribal areas? India respects its diverse cultures and traditions. Nagaland and tribal areas have their own special ways of life, languages, and customs. Applying the law directly might not always work for them. That's why their government is allowed to make changes before applying the law. Masterpiece summary, in a nutshell. 1. The government of Nagaland or a tribal area can decide if they want to use parts of the law. 2. They can make it work in the whole state, part of it, or not at all. 3. Can add or change the rules to fit local needs. 4. They must make an official announcement explaining everything. 5. This flexibility ensures respect for the unique cultures of Nagaland and tribal areas. If you have more questions or want examples, I'm here to help. Let's break this down step by step in the simplest way possible. In this section, tribal areas means the territories, which immediately first day of January 1972 were included in the tribal areas of Assam, as referred to in paragraph 20 of the 6th schedule to the Constitution, other than those within the local limits of the municipality of Shillong. Breaking it down. 1. In this section, tribal areas means the territories. What is a section? A section is a part of a law that explains a particular rule or idea. What are tribal areas? These are special regions where certain tribes live, usually with their own customs, traditions, and practices. Territories means the specific areas or lands. So tribal areas refers to certain lands where tribes live. 2. Which immediately before the 21st day of January 1972 were included in the tribal areas of Assam. What happened on the 21st day of January 1972? On this date, parts of Assam, a state in India, were recognized as tribal areas because they were home to tribes with their own special rules and customs. Included in the tribal areas of Assam means these lands were part of Assam's tribal areas before January 21st, 1972. As referred to in paragraph 20 of the 6th schedule to the Constitution. What's the 6th schedule? The 6th schedule is part of the Indian Constitution that lists out specific areas where special rules apply due to their tribal nature. Paragraph 20 refers to a section of the 6th schedule that explains what tribal areas are and where they are located. In simple terms, the Constitution had already mentioned these areas as tribal in a specific part. Paragraph 20. 4. Other than those within the local limits of the municipality of Shillong. What's Shillong? Shillong is the capital city of Meghalaya, another state in India. Why mention Shillong? The tribal areas near Shillong, the municipality area, are treated differently. The special tribal status and rules might not apply to these areas because they are more urban or developed. Sentence. It shall come into force on such date as the central government may, by notification in the official gazette, appoint. Breaking it down. 1. It shall come into force. Come into force means the law or rule will start applying. The law or rule mentioned here will begin on a specific date that the central government decides. 2. On such date as the central government may, by notification in the official gazette, appoint. Who is the central government? The central government of India, which manages the entire country's rules and regulations. What is a notification in the official gazette? The government announces important things like new laws or changes through a publication called the official gazette. What's the meaning here? The central government will decide on a specific date when this rule about tribal areas will start applying, and they will notify it through the gazette. Summary. 1. Tribal areas refer to special regions in Assam recognized as tribal areas before January 21st, 1972, as mentioned in the Constitution. 2. Shillong area is excluded from these tribal rules because it's more urbanized. 3. The central government will decide on a specific date when the rules here will come into force, and they'll announce it officially in the Gazette. In simple terms, tribal areas are defined as specific lands in Assam before a certain date. Shillong is not included. The central government will decide when the rules will take effect and inform everyone officially. Let's break this down step by step in the simplest way possible without using any complex terms. Sentence. Our law of criminal procedure is mainly contained in the Code of Criminal Procedure, 1973, CRPC. What is criminal procedure? Criminal procedure means the rules and steps that are followed when dealing with crimes. The Code of Criminal Procedure, 1973, CRPC, is the main law in India that tells how criminal cases like theft, murder, etc. are handled. In simple terms, it explains how police investigate, how courts handle criminal cases, and how punishments are decided. The code extends to the whole of India except the state of Jammu and Kashmir. Extend to the whole of India means these rules apply everywhere in India except Jammu and Kashmir. Why? Because Jammu and Kashmir had a special status at that time, so the laws did not apply there until later changes. Example. Imagine a set of rules for schools, but some states decide to follow different rules because they have their own unique conditions. Sentence. Further, some of the provisions of the code have not been made applicable at present to the state of Nagaland and the tribal areas in Assam because of the peculiar conditions prevailing there. What does this mean? Certain rules in the Criminal Procedure Code don't apply to Nagaland and tribal areas in Assam at this time. Why not? Because these areas have special conditions like different cultures, customs, and traditions that need to be respected. Example, think of areas with different customs, like maybe some villages follow their own unique ways of solving disputes. The law doesn't force one size fits all. It respects local ways. Sentence. Though the procedure to be followed in these areas is not required to be strictly in accordance with the provisions of the code, yet it must satisfy the standard of fairness as is implicit in Article 21 of the Constitution. What does this mean? Even though certain laws don't apply strictly in these areas, Nagaland and tribal Assam, they still need to be fair and just as mentioned in Article 21 of the Indian Constitution. Article 21 of the Constitution says, "No person shall be deprived of life or personal liberty except according to a procedure established by law." So, fairness and justice should still be followed, even if the specific rules of the Criminal Procedure Code don't apply. Example. Imagine there's a game in a school. Different schools follow different rules, but everyone agrees that the game should be played fairly. Even if the rules differ, fairness is a must. Summary. CRPC applies to the whole of India except Jammu and Kashmir. In Nagaland and tribal areas of Assam, some rules don't apply because of local conditions. However, fairness and justice must still be followed as required by Article 21 of the Constitution. It's like applying general guidelines, but allowing for local conditions to make sure justice is still served fairly. Let's break this down step by step to understand everything in the simplest way possible. Sentence. The provisions of the code are applicable in respect of every investigation, inquiry, or trial of any offense under the Penal Code, 1860, IPC, or under any other law. Provisions of the code. These are the rules and steps mentioned in the Criminal Procedure Code, CRPC of 1973, which tells us how crimes should be handled by the police and courts. IPC, Indian Penal Code. This is the law that lists crimes like theft, murder, etc., and their punishments. Other laws. There are other laws that also deal with different types of crimes or specific situations, such as laws related to special areas or special crimes like terrorism, drug offenses, etc. What this means, the rules under CRPC apply whenever there's an investigation, inquiry, or trial related to any crime under IPC or any other law. Sentence. However, the rule is not unduly rigid. Not unduly rigid. This means the rules are not strict or too hard to follow all the time. Sometimes the situations are unique, like in remote areas or with special kinds of crimes, and those situations might require different or simpler rules. The law is flexible to accommodate these special situations. If the exigencies of the subject matter or of the local conditions require a special procedure to be followed in respect of certain offenses, the code makes room for such special law and procedure. Exigencies of the subject matter. This means special or urgent needs related to the type of crime being dealt with. Local conditions. These are the special conditions of a particular place, like tribal areas, remote regions, or certain cultural practices. Special procedure. If the regular procedures in CRPC cannot work in certain areas or for certain crimes because of local conditions or the nature of the crime, the law allows special rules to apply. Example: a crime like theft in a remote tribal area may have special ways of investigation because of the local customs, culture, or difficulty in accessing resources. The usual police procedures might not fit those unique conditions. Sentence generally gives it precedence over the normal procedure provided by the code. Gives precedence. This means the special law or special procedure will be more important or take priority in those special situations. Normal procedure. The usual rules in CRPC that apply to most crimes. In special situations, like in certain areas or with certain types of crimes, the law allows a different or simpler set of rules to take over instead of the regular CRPC rules. Example: in tribal areas, there might be local councils or leaders who handle certain disputes instead of courts following the usual procedures. The special local rules take precedence here. Hash summary. The CRPC applies to crimes under the IPC or other laws. However, if local conditions or the nature of the crime require different procedures, like in remote areas or certain special situations, the law allows special rules to apply. These special rules take priority over the regular ones in those cases. The main goal is to ensure fairness and justice while respecting local conditions. Let's break this down step by step and explain it in the simplest way possible. Sentence: the code has been passed by Parliament. The code refers to the Criminal Procedure Code, CRPC, which is a set of rules made by the Parliament of India to handle crimes, investigations, trials, etc. Parliament. The Parliament is the highest lawmaking body in India, made up of elected representatives. When they pass a law, it becomes official and applies to the entire country. Sentence: but as the subject of criminal procedure is included in the concurrent list in the 7th schedule appended to the Constitution. Concurrent list. This is a part of the Indian Constitution where both Parliament and state legislatures have the power to make laws. Criminal procedure, like how crimes are investigated, trials happen, etc., is included in this list, meaning both the central government, Parliament, and state governments have authority to make laws or changes related to criminal procedure. 7th schedule. A list in the Constitution that divides subjects into different categories, like union list, state list, and concurrent list. Sentence: a state legislature may, in accordance with the provisions of the Constitution, modify the provisions of the code. State legislature. The government of each state has its own assembly or legislature that can make laws on certain topics, modify the provisions of the code. States can make changes to the CRPC if they feel certain rules need to be adjusted based on their local conditions or needs. Constitution allows this. The Constitution gives both central and state governments the power to make rules, and the states can modify the rules if needed. Sentence: the modified provisions of the code would then apply to that state. Modify provisions. If a state decides to make changes to the CRPC based on its local needs, those changes apply only to that state. Example: a state like Nagaland, with its own unique conditions like tribal customs or geography, can have slightly different rules compared to other states. Only that state. The changes made apply only within that state, not across the whole country. Sentence. Thus, it would be seen that while the code provides for a uniform criminal procedure applicable throughout India, uniform criminal procedure, The CRPC applies to crimes and investigations in all states in India. Across India, the idea is to have a common set of rules for how crimes are dealt with everywhere. Sentence. Sections 1, 4, and 5 of the Code and the provisions of the Constitution of India make it sufficiently flexible to adjust itself to the special local needs and conditions. Sections 1, 4, and 5. These sections deal with important aspects like the extent of the CRPC and how it applies to different parts of India. Constitution provisions. The Constitution allows for flexibility so that different areas, like states or regions, can have rules that fit their unique situations, like different laws for tribal areas or remote regions. Special local needs and conditions. Each state or region has its own problems or special conditions, like customs, geography, or culture, that might require different laws or rules. Summary. The CRPC is made by Parliament to apply across India. Since criminal procedure is listed in the concurrent list, both the central government and state governments can make rules related to criminal procedure. States can modify the CRPC if their local conditions require special rules, making it flexible to fit different areas. This ensures that while there is a common set of rules, for fairness and uniformity, adjustments can be made to fit the unique needs of each state.
Let's take this slow and explain it in even more detail, step by step, using very simple words. What are territorial divisions? Imagine India is a very big country, like a giant cake. To make it easy to manage, we need to cut the cake into smaller pieces. These pieces are called territorial divisions. Why do we need these divisions? If we didn't divide India, it would be too hard to manage. For example, if the government wanted to build a road, where would they start? Or if someone broke a law, how would they know where to take the person for justice? Divisions help to make things clear and simple. Each smaller part takes care of its own area. How is India divided? We'll divide it step by step, like a pyramid. 1. India is divided into states. India has many states, like Uttar Pradesh, Gujarat, and Kerala. A state is like a big part of the cake. Each state is managed by its own government, called the state government. 2. States are divided into sessions divisions. Now each state is cut into smaller parts called sessions divisions. Some states may have only one sessions division if the state is small. Bigger states may have many sessions divisions. 3. Sessions divisions are divided into districts. Next, every sessions division is further cut into districts. A district is like a city or a large area. For example, in Uttar Pradesh, there are districts like Lucknow, Kanpur, and Varanasi. Each district has its own offices and officers to handle schools, hospitals, roads, and justice. Districts can be divided into subdivisions. If a district is very large, it is broken into smaller parts called subdivisions. A subdivision is a very small area, usually a group of towns or villages. What about big cities? Some cities are very big, with more than 1 million people, like Mumbai, Delhi, and Kolkata. These cities are called metropolitan areas. They are treated as special areas because they are important for trade, jobs, and government work. They need more attention to solve their unique problems. How are metropolitan areas managed? A metropolitan area is treated as 1. A separate sessions division. 2. A separate district. This means the city gets its own special officers to handle laws, problems, and justice. For example, Mumbai is in Maharashtra state, but it is a separate district and a metropolitan area. It has its own police, courts, and officers to manage the city. Who decides how to divide India? The state government decides. How many sessions, divisions, districts, or subdivisions are needed? If a division needs to be bigger or smaller, but the state government can't do this alone, it needs to ask the High Court of the state. Why is this system good? 1. Better management. Divisions make it easier to build roads, schools, and hospitals. 2. Fair justice. Every area has its own courts to handle crimes and disputes. 3. Special care for big cities. Cities like Delhi or Kolkata get extra attention because they have more people and problems. Example to understand better. Let's imagine 1. India is a big school. The school has many students, so the principal divides the school into smaller groups. 2. States are like classes. Each state is like a class, class 1, class 2, etc. Every class has its own teacher, state government. 3. Sessions divisions are like groups in a class. Each class is further divided into smaller groups, Group A, Group B. 4. Districts are like rows in a group. Each group is divided into rows and every row has a monitor to manage it. 5. Metropolitan areas are like VIP students. Big cities like Mumbai are like special students who get extra attention. Key points to remember. 1. India is divided into smaller parts, states, sessions divisions, districts and subdivisions for easier management. 2. Big cities are treated as special areas called metropolitan areas because they have unique needs. 3. State governments decide the divisions, but they must talk to the High Court before making changes. Let me know if you want this explained even more. Alright, let's go even simpler and explain this topic step by step using small sentences and examples. What does classification of offences mean? In any country there are laws. Breaking these laws is called an offence. Some offences are serious, like murder. Some are not so serious, like making noise in public. The law divides these offences into 2 groups. What are the 2 groups of offences? 1. Cognizable offences. 2. Non-cognizable offences. What is a cognizable offences are serious crimes. The police can arrest the person immediately without needing permission from a judge. The police can also start investigating the case directly. Examples of cognizable offences: murder, killing someone; kidnapping, taking someone away by force; rape, hurting someone sexually; theft, stealing something valuable. Why can police act fast? These offences are dangerous, so the police need to act quickly. For example, if someone commits murder, the police must catch them fast to stop them from escaping. What is a non-cognizable offence? Non-cognizable offences are less serious crimes. The police cannot arrest the person immediately. They need permission from a judge before arresting the person or starting an investigation. Examples of non-cognizable offences: public nuisance, making loud noises in public; defamation, damaging someone's reputation; minor fights, slapping or pushing someone. Why do police need permission? These offences are not urgent or life-threatening. For example, if someone writes something mean about you, the police will first ask a judge if they can investigate. How does the law decide whether an offence is cognizable or non-cognizable? The first schedule in the law book lists all the offences. It clearly tells whether each offence is cognizable, serious; non-cognizable, less serious. How to know if an offence is serious or not? The law uses punishment to decide. 1. If the punishment is 3 years or more in jail, it is usually a cognizable offence. Example, murder has life imprisonment, so it is serious. 2. If the punishment is less than 3 years, it is usually a non-cognizable offence. Example, making loud noises may only result in a fine, so it's less serious. Why is this division important? 1. It helps the police act quickly for serious crimes. Example, in a kidnapping case, the police can start searching immediately without wasting time. 2. It prevents police from misusing their power for small issues. Example, if someone complains about loud music, the police will ask the judge first. Differences between cognizable and non-cognizable offences. Cognizable offences, non-cognizable offences. Seriousness, serious crimes, less serious crimes. Police action, can arrest without permission, need judge's permission, investigation. Police can start directly. Police need judge's approval first. Examples: murder, rape, theft; public nuisance, minor fights to make it clearer. Example 1. Cognizable offence. Imagine someone steals your car. This is a serious offence. The police can arrest the thief without asking a judge. They can start investigating the case immediately. Example 2. Non-cognizable offence. Imagine your neighbour is playing very loud music at night. This is not serious. The police cannot arrest your neighbour immediately. They need to ask a judge for permission first. Summary. Cognizable offences equals serious. Police act fast without permission. Non-cognizable offences equals less serious. Police need permission first. The first schedule in the law lists which offences are serious or not. If punishment is 3 years or more, it's serious. If punishment is less than 3 years, it's less serious, non-cognizable. Let me know if you need more examples or further explanations. Let's break it down even more clearly and with more examples. What is a cognizable offence? A cognizable offence is a type of crime where the police 1. Do not need permission from a magistrate to take action. 2. Can arrest the person and investigate immediately. Why is this important? These crimes are serious and urgent. They involve danger to people or society. Delaying action could lead to more harm. What can the police do in cognizable offences? 1. Arrest without warrant. Usually police need a warrant, official permission from a magistrate to arrest someone. But in cognizable offences, the police don't need to wait for a warrant. Example 1. A person is caught stealing money from a shop. The police can arrest them on the spot. Example 2. If someone is found attacking another person with a weapon, the police can immediately take them into custody. 2. Start investigation without permission. In normal cases, police need a magistrate's order to start an investigation. For cognizable offences, the police can start collecting evidence, questioning people, and investigating immediately. Example 1. If there is a murder, the police can visit the crime scene, collect evidence, and question witnesses without asking a magistrate first. Example 2. If there's a robbery in a house, the police can begin searching for the thief without waiting for orders. The role of the police. The law requires the police to act in cases of cognizable offences. It is their duty to 1. Arrest the offender, the person who committed the crime. 2. Investigate the crime to find out what happened. 3. Collect evidence to prove the crime in court. 4. Bring the offender to court for justice. Who is responsible for justice? In cognizable offences, it is not just the victim's problem. The state government and the police are responsible for taking action. This is because these crimes affect the whole society, not just one person. Examples of cognizable offences. Here are some common examples to make it even clearer. 1. Murder. If someone kills another person, the police can arrest them immediately without waiting for a warrant. 2. Kidnapping. If a child is kidnapped, the police can start looking for the child and arrest the kidnapper right away. 3. Robbery. If a thief steals from a shop, the police can investigate and arrest the thief without asking for permission. 4. Rape. In cases of rape, the police can take quick action to arrest the accused and investigate the case. Why are cognizable offences serious? These offences cause serious harm to people or property, create fear in society, need immediate action to prevent further harm. How is justice ensured? The police take action quickly by arresting and investigating. The court then decides if the accused is guilty and what punishment they should get. Summary. 1. Cognizable offences are serious crimes. 2. The police can arrest the offender without a warrant, investigate the crime without asking a magistrate. 3. It is the responsibility of the state to ensure justice is served. 4. Examples: murder, robbery, kidnapping, rape, etc. Let me know if you want even more clarification. Alright, let's break it down further in the simplest and easiest way, step by step. What is a non-cognizable offence? A non-cognizable offence is a crime that is not very serious. In these cases, the police cannot arrest someone or start an investigation on their own. They need 1. A warrant, permission to arrest from a magistrate. 2. An order from a magistrate to start an investigation. Step-by-step explanation. 1. Police cannot arrest without permission. Normally, the police can't just go and arrest someone in a non-cognizable offence. They first have to go to the judicial magistrate, a judge who handles such matters, and ask for permission. Only after the magistrate gives a warrant can the police arrest the person. Example 1. If someone insults another person, the police can't arrest them immediately. They need a warrant from the magistrate. Example 2. If someone writes a nasty comment on social media, defamation, the police can't arrest that person without the magistrate's approval. Police cannot investigate without permission. The police cannot investigate these cases on their own. They need to get an order from the magistrate to begin the investigation. What does this mean? The police can't collect evidence, question people, or start any legal process unless the magistrate tells them to. Example, if someone complains that their neighbour broke a small part of their property, minor damage, the police must first ask the magistrate if they can investigate the case. 3. Magistrate plays an important role. The judicial magistrate decides if the police can take action or not. Victims of a cognizable offence have to go to the magistrate and file a complaint. If the magistrate thinks it's necessary, they will give the police permission to investigate an act. Example, if a shopkeeper accuses a customer of giving a fake note forgery, the magistrate will decide if this case needs police action. Exceptions, special cases. 1. Immediate arrest in certain situations. If a non-cognizable offence happens in front of a police officer and the person refuses to give their name and address, the officer can arrest them without a warrant. This is to find out who they are. Example, a person is caught painting graffiti on a public wall, minor vandalism, but they refuse to say their name or address. The police can arrest them to find out their identity. 2. Mixed cases, cognizable plus non-cognizable. If a case involves both a serious offence, cognizable, and a less serious offence, non-cognizable, the whole case will be treated as a cognizable offence. This allows the police to act quickly without needing permission. Example, if someone robs a shop, cognizable, and also verbally abuses the shopkeeper, non-cognizable, the case will be handled as cognizable. 3. Magistrate can allow investigation. Even though the police cannot normally investigate non-cognizable offences, the magistrate can give them permission to do so. Once the magistrate gives an order, the police can investigate and collect evidence as they would in a serious case. Why are non-cognizable offences different? Non-cognizable offences are less harmful or affect only individuals, not society as a whole. These cases are seen more as private disputes, and the responsibility of collecting evidence or prosecuting the offender lies more with the victim or private person. Examples of non-cognizable offences: defamation, hurting someone's reputation; public nuisance, playing loud music at night; minor assault, pushing someone during an argument; forgery, changing details in a document. What happens in a non-cognizable case? 1. Victim files a complaint. The victim reports the offence to the police. 2. Police approach the magistrate. The police ask the magistrate for permission to investigate or arrest. 3. Magistrate decides. If the magistrate feels the case is important, they give an order or warrant. 4. Police take action. After getting permission, the police investigate or arrest. Why does this system exist? It prevents police from misusing their power in minor cases. It ensures that less serious offences are handled carefully and fairly. It gives the victim a chance to approach the magistrate if they feel strongly about the offence. Simple summary. Non-cognizable offences are less serious crimes. Police cannot arrest or investigate without a magistrate's permission. The magistrate plays a big role in deciding if the police should act. These cases usually involve private disputes or minor wrongs. If you have more questions or need further examples, feel free to ask. Sure, let's go step by step and explain everything in even more detail and in the simplest way possible. Imagine we are learning this for the first time. Duties of police officers. A police officer's job is to keep society safe and peaceful. To do this, they have specific duties. Let's break it down. 1. Obey orders and warrants. What does this mean? If someone with legal power, like a magistrate, order or issues a warrant, the police must follow it quickly. An order like, go to this place and handle the situation. A warrant is permission to arrest or search someone legally. Example, if a magistrate tells the police to arrest a thief, the police must act immediately and arrest the thief. 2. Collect and share information. What does this mean? The police need to find out what's happening in their area, especially things that could disturb peace, like fights, protests, or illegal activities. They must share this information with their team or senior officers to take action. Example, if the police learn that people are planning to protest without permission, they inform their seniors and stop it from getting out of control. 3. Prevent crimes and public nuisances. What does this mean? The police must stop crimes before they happen. They also stop public nuisances, which means anything that bothers the public or breaks rules. Example, if the police hear about a plan to rob a bank, they act quickly to stop the robbery before it happens. If someone is playing very loud music late at night, the police stop them because it's disturbing others. 4. Catch criminals and bring them to justice. What does this mean? If someone commits a crime, the police must and ensure they face legal action. This is called bringing them to justice. The police don't punish, they take the criminal to court. Example, if someone steals a car, the police investigate, catch the thief and take them to court. 5. Arrest people legally. What does this mean? The police can only arrest someone if 1. They are legally allowed to do so. 2. They have strong reasons to believe the person has done something wrong. Example, if someone is caught selling illegal drugs, the police can arrest them because it's a crime. 6. And inspect certain places without a warrant. What does this mean? For specific situations, police can enter and check places without needing special permission, a warrant. These places include drinking shops, where alcohol might be sold illegally, gaming houses where illegal gambling might happen, other places where troublemakers gather. Example, if the police suspect illegal gambling in a house, they can enter and inspect the house without waiting for a warrant. Extra details to make it clearer. Who are loose and disorderly characters? These are people who cause trouble in public, do illegal things like gambling or drinking in banned areas, disturb others with bad behavior. What is public nuisance? Public nuisance means anything that bothers the public or breaks rules in public places. Examples, loud music in a quiet neighborhood, selling banned items in a market, blocking a public road without permission. What is a competent authority? A competent authority is someone with legal power, like a magistrate, a senior police officer. Why are these duties important? 1. Safety. Police duties ensure people feel safe in their homes and public places. 2. Law and order. Without police, rules wouldn't be followed and crimes would increase. Peace. Preventing trouble helps society stay peaceful and organized. Example of how these duties work together. Let's see how police handle a situation. Scenario. A police officer learns about a group planning to gamble illegally in a house. 1. Collect information. The police hear this from someone in the neighborhood. 2. Prevent crime. They go to the house to stop the gambling before it happens. 3. Enter and inspect. They inspect the house without a warrant because it's a suspected gaming house. 4. Arrest. If they find people gambling, they arrest them. Bring to justice. The arrested people are taken to court for punishment. Summary. Police officers have 6 main duties. 1. Follow orders and warrants. 2. Collect and share information about public safety. 3. Stop crimes and nuisances. 4. Catch criminals and bring them to justice. 5. Arrest people legally. 6. Enter and inspect certain places without a warrant. These duties are essential for keeping society safe, peaceful and organized. Let me know if you'd like to dive deeper into any part. Let's break this down further into simple, easy to understand points so nothing is confusing. Penalties for neglect of duty. Detailed explanation. This law explains what happens if a police officer does something wrong or doesn't do their job the way they are supposed to. It lists specific situations where a police officer can be punished and the penalties they might face. What happens when a police officer breaks rules? A police officer can be punished if they 1. Don't perform their duty properly. If a police officer ignores their responsibility or does their job poorly, poorly. A police officer is supposed to stop a fight but just watches instead of acting. 2. Disobey orders or rules. Police officers must follow all legal orders and rules given by senior officers or laws. Example, if a senior officer says, arrest this person, but the officer refuses without a good reason. 3. Leave work without permission. A police officer cannot quit or stop working without telling their department. They must give a notice of at least 2 months before leaving. Example, an officer decides to stop working suddenly without telling anyone. 4. Don't return after leave. If an officer is on vacation or leave, but doesn't come back to work on time and doesn't have a good reason for the delay. Example, an officer's leave ends on January 1st, but they don't show up for work until January 10 without explaining why. 5. Do another job without permission. Police officers are not allowed to work another job unless their department gives them special permission. Example, a police officer starts working as a private driver while still being employed in the police force. 6. Show cowardice. A police officer is expected to be brave. If they run away or fail to act during dangerous situations, it's called cowardice. Example, during a robbery, a police officer hides instead of trying to stop the robbers. 7. Hurt someone in custody. If a police officer harms someone in their custody, someone they arrested without a valid reason, they are guilty of wrongdoing. Example, an officer arrests someone for theft and beats them unnecessarily while in custody. What are the punishments? If a police officer is guilty of any of these actions, they can face 1. Loss of salary. The officer may lose up to 3 months of their pay. Example, if an officer earns $30,000 per month, they might lose $90,000 as punishment. 2. Jail time. The officer can be sent to jail for up to 3 months. Jail time may involve hard labour, like cleaning, building work, etc. 3. Both salary loss and jail. In some cases, the officer can face both punishments. What makes this law important? 1. Maintains discipline. It ensures that police officers follow the rules and do their job properly. 2. Protects the public. If officers are not punished for their mistakes, people will lose trust in them. 3. Ensures accountability. Police officers have power, but this law ensures they don't misuse it. Real-life examples to make it clearer. Example 1. An officer refuses to follow an order to arrest a criminal. Punishment. The officer loses 3 months of their salary. Example 2. An officer leaves work without informing anyone and doesn't come back for weeks. Punishment. The officer is sent to jail for 2 months. Example 3. An officer harms a person in custody without a valid reason. Punishment. The officer faces both 3 months in jail and 3 months salary deduction. Extra points to remember. 1. Police officers have big responsibilities. They are supposed to maintain peace, help people and enforce the law. 2. This law is to prevent misconduct. It makes sure that officers don't take their job lightly. 3. Punishment depends on the violation. Small mistakes might lead to salary loss, while bigger issues like violence or cowardice might lead to jail time. Summary. 1. Police officers can be punished for ignoring duties, disobeying rules or acting wrongly. 2. Punishments include loss of up to 3 months' salary, jail for up to 3 months, both salary loss and jail in serious cases. 3. The law ensures police officers are disciplined and trustworthy. If you want more examples or any specific part explained further, feel free to ask.